In 1961, the Supreme Court decided 5-4 that a lawyer could be disbarred for not providing evidence to a legal investigation. The court would reverse its decision in just 6 years. Basically, they got it wrong. What about the Fifth Amendment? I started my research into pro se at the Supreme Court with a list from an article in St. Mary's Law Journal. There's not much information out there about Cohen v. Hurley, not even a Wikipedia article. It turns out that the Law Journal paper had a mistake on this one too. Here's the background. Albert Cohen was a lawyer caught up in an investigation by New York State. That dragged on, and it even reached the Supreme Court before.
This is the 5th time that a problem arising in this judicial inquiry in Kings County, New York, has come before this court. The 2nd time that oral argument has been permitted.
Cohen refused to provide evidence which would incriminate himself and got disbarred.
He was asked to produce his books and records, including his bank accounts and things of that kind. He was asked some 60 different questions, touching on and relevant to, unquestionably, his professional conduct in some of these retainer cases. There's no doubt about the relevancy of the question. There's no doubt about the propriety of the inquiry. But he took the position, on the advice of able and experienced counsel, and in the utmost good faith, that under the Constitution of the United States and the Constitution of the State of New York, he was entitled not to become a witness against himself.
This is marked as a pro se case, so the Law Journal article assumed that it was the disbarred attorney coming into the Supreme Court to defend himself. Pretty epic. But he was represented by Theodore Kindle in arguments.
Well, if Your Honor, please, our position is this, that the question that is essentially presented here is this. Did the state violate due process?
It was the respondent, Dennis Hurley, who came to the court pro se. Here's his argument that lawyers should be held to a higher standard.
That when a lawyer is admitted to the bar, he presents himself for admission and he is admitted to the bar, the effect seems to be that the court, the admitting court, is representing to society at large that here is an honorable man worthy of the public's trust and confidence, worthy to uphold the honor of the profession and, as its officer, the dignity of the court.
Basically, when a licensed attorney represents himself or herself in front of the Supreme Court, that also is considered pro se. In the 60s, it was common for state officials to take their own cases to D.C. After John Roberts became Chief Justice, there were only 2 such cases in 2006, and then 1 was allowed in 2019. That change seems intentional. Okay, so this is a case with an attorney representing himself. Not that unusual. But while we're here, how did Cohen lose? What about the Fifth Amendment? Here's a curveball. The Fifth Amendment didn't apply to states then. Until Malloy v. Hogan a few years later, our most awesome constitutional rights were more of a federal thing, and each state had their own version of those rights in the Constitution. Or they didn't.
I can understand that he brings himself under jeopardy under the state guarantee against self-incrimination. I don't understand things. See how he comes within the scope of the protection of the Fifth Amendment.
Nowhere is there any allegation, either in the pleading or in the testimony of the Fifth Amendment. And also, in answer to a question yesterday, we do not investigate federal crimes. This is a state inquiry by the court.
Imagine if we were holding to that version of the Constitution today. States could ignore the First Amendment and establish their own state religion. That would be crazy.
They ask you how you are, you just have to say that you're fine.
After Justice Frankfurter's retirement, Kennedy would appoint Justice Goldberg, flipping a vote and making Malloy v. Hogan possible. Then, Lyndon B. Johnson convinced Goldberg to become UN ambassador and appointed Justice Abe Fortas. With 1 vote flipped and the Fifth Amendment on the board, Spivak v. Klein overturned Cohen v. Hurley.
Cohen against Hurley, in which by the same majority you upheld the disbarment of a lawyer who was held by the majority in that case to have pleaded only his state privilege against self-incrimination. That case also was decided before New York and the other states were required to give recognition to the Fifth Amendment, that requirement being imposed by your decision in Malloy against Hogan.
And that's more or less how lawyers regained their right against self-incrimination. If you want to hear more episodes about people representing themselves at the Supreme Court, please like and subscribe. United States Supreme Court rules and practices have changed since these cases. This was a podcast episode, not legal advice.